The state has spent a lot of time trying to make this homicide case about an argument where my client was acting boorishly and inappropriate. I think I told you in the beginning I didn't think you would find that his behavior was okay inside Tabby's. It wasn't. But this case isn't about bad behavior inside this bar. It's not. Mr. Davies was never injured inside Tabby's. There are really two issues. They're complicated, factually, but there's really two issues. First, not complicated, did Mr. Sehmer batter, punch Mr. Davies? That's one issue. If you determine that my client didn't batter him, didn't punch him, then that's it. Then it's not guilty. As simple as that. I think that's what happened here, and I think that's what the evidence shows. But let's just kind of break it down so that you can understand, because it's a little complicated. The second issue is, well, if we thought he battered Mr. Davies, was he acting in self-defense? That is, was he doing whatever he did because he was being assaulted by Mr. Davies? I indicated initially, that is in the opening statement, that this was an argument that had already ended. Now, I'm not asking, or should I ask, that you not consider the fact that my client had been acting badly in the bar. I mean, that's obviously evidence in the case. It's, however, as I again would state, that's not where Mr. Davies was hurt. So they had, that is, Mr. Sehmer and the two women were talking, okay? I doubt they particularly liked Mr. Sehmer, although they did both stay there, and they were talking. It wasn't a long time. At some point, my client, gives a hug to Ms. Burke, but whatever, and they were standing together, the two women. And if Mr. Davies doesn't come in the bar and start screaming to Mr. Sehmer and to his wife, are you still talking that blah, blah, blah? There's no event. And there isn't. So while it doesn't mean that what my client had done previously doesn't matter, but it is like, well, okay, the facts of this case are that it really had kind of stopped. It didn't make him not a bore in his behavior, but it was over. And then Mr. Davies came back in. I think, based upon the evidence, is that he didn't like the fact that his wife was still talking to him. I mean, I kind of get it. It makes kind of sense. He's probably thinking, why are you talking to that jerk? I mean, he was just rude to me. So I get that. I mean, I do. I'm not critical of Mr. Davies. I'm not. I mean, I get it. He was mad at that point, and probably more mad at his wife. But he was mad. And then when my client hears this, my client then goes out of the bar. And the two women try to stop him. It doesn't quite work. He gets upset. And they try to get him out. I mean, they try to get him to not go out because he had been angry already once. Okay? But then what happens? Okay? Now, you're going to see, this is what Ms. Burke wrote that night about what happened. And you remember, she was, she didn't go outside like Ms. Davies did. She says, from inside, I saw through the window that Josh had a chair raised above his head. Now, this is not Mr. Sehmer saying this. Okay? Let's be clear about this. This is not Mr. Sehmer's statement. This is Ms. Burke's statement, a longtime friend of Ms. Davies and a friend of Josh's. She is the one who says that night he had a chair raised above his head to hit Kevin as he approached. That's her statement, not Mr. Sehmer's. I think I overheard someone say he has a chair or he's going to hit him with the chair. Again, this is Miss Davies and Josh's friend. That's what she saw that night, not Mr. Sehmer. She saw it that night. Now, Ms. Davies, she says that her husband picked up a chair or a stool to defend himself. And she's, not very happy with Mr. Sehmer at this point. And she says, the man who I know as Kevin ran after him screaming at my husband about God and tattoos. My husband defended himself and picked up a chair or a stool to defend himself from this crazy person who went after him for no reason. Okay. Well, what does that mean? Well, it is that night, and I do understand that she was upset. Okay? This was, in fact, traumatic for her. Her husband was now in a hospital while they're doing, that is, medical professionals are doing things to help him. She has an opportunity to write this statement out. Now, and I understand that people, when they're upset, maybe they're not as clear as we'd like. But what's disturbing is that what she should have been upset about, if her current story is true, that is, if she believed, based upon what she saw, that Mr. Sehmer punched her husband, causing him to go to the ground. Is it reasonable? Is it in our life experience that you would exclude the single most important fact of this incident? This thing that has put your husband in the hospital, that you would not include what it is that she now says is the reason he was in that hospital, the punch. Now, with all due respect to Mrs. Davies, this is a difficult circumstance. I get that. But when I asked her about why she didn't include it, she seemed to suggest that, I thought we were all going home. That's kind of what she said. That's really not unreasonable. Not only is it not reasonable, it's kind of ridiculous. It is impossible to believe that that's the excuse that you didn't write. He punched my husband. Had she really seen him, my client, punch her husband and has him go to the ground, it would be the single most important thing she wanted to make certain that law enforcement knew. He punched him, but she didn't. She went part of the way and said that he picked up a stool to defend himself, which is like what Ms. Burke said. The two women there both said the same thing. He picked up this stool. And I think Ms. Davies says he had it up here by his head. Ms. Burke said it over his head. I don't know that it really matters, okay? But if we take, for example, Ms. Davies' statement, it's here by, kind of above his shoulders. And she also, having acknowledged that he did that, she also in her statement doesn't say that he chucked, I think was her word, I hope that's right, but something like he chucked the stool at Mr. Sehmer. Now again, just as it is difficult to understand or find credible that you would do this, you would write this statement and not include that he, Mr. Sehmer, punched him. It's also difficult to understand how you're actually writing about the fact that he had this stool to defend himself and not say, well, how did he do that? It is kind of an interesting absence, okay? Now we have the, I'm not including that he was punched, even though I'd seen it, supposedly, but I'm not going to include what he did with the stool or chair. Everybody thinks it's a stool, a metal stool. So instead, she waits till the trial, not in her statement, to say, well, he just chucked it. Well, you would have said that night. Yeah, he had a chair, but he just threw it on the ground, or threw it towards him, but didn't do anything. I mean, she says to defend himself, well, okay, how? Now, it doesn't matter that she doesn't have all the details, but the two important details are, one, say that your husband was punched by my client, and two, and what he did with the stool that he was defending himself with. So those two witnesses, the state seems to suggest, tell the same story, and they kind of do. The story, though, is that Mr. Davies had a stool and used it to defend himself. And in fact, somebody even screamed, he's going to hit him. I mean, that's what they said that night. That's what they said that night. It's a different story now, but I get that. But the government has to prove this case. And I'm sorry, it's a bit odd to suggest, well, I know this is really complicated. And I mean, they're all telling different stories. As if in our system, you can convict somebody of a crime, a serious crime, even though, well, nobody really knows what happened. They don't really know because they all saw things and they're all different things, and yeah, that's okay. Well, is it? Is it okay that they can't tell a story that makes any sense? Some of it is just simply not sensible. But that's what the state is asking us. Now, the other thing that's a little odd is that Ms. Davies, again, I'm not trying to be mean to her, she says that she was actually right with my client. I mean, with her husband. I mean, she was right next to him. Now, you're going to see these videos because I'm going to play them because they really kind of matter. What you're not going to see is Jennifer Davies anywhere near there. I mean, nowhere near her husband. I mean, she's just not there. Now, one of the witnesses says, well, she never came out. But she's not there, okay? Which is a little odd because given what you're going to see and already have seen in these videos, you're going to see that Josh does kind of launch himself. I mean, if you look at it slowly, you can see he literally is launching himself. And he then, something happens and he goes down. Now, the state can say, yeah, there's the follow-through of a punch that we can't actually see. I don't know. I don't know how much counsel knows about boxing, but it's not like that. So she was right there. Presumably, if she were right there, you remember how we see he just goes down. She'd be right there. And there are reasons that we would think, one, she wasn't there, and two, if she was, we'd have seen her. But she wasn't. So the videos, and we're going to play them, and I'm not going to play just one, and I'm not going to play the first one. We're going to use the enhanced slowed one, okay? Because I want to show you some stuff, okay? And I think it would be fair to say that any of us who have been dealing with this, and now you folks, have to deal with these videos, and they are hard, okay? They're hard. they're hard because you're looking at various different things. You're trying to look and see where maybe somebody's legs are, where somebody's hands are, where their head is, where they are, where they're moving. But I just want to show you these videos because you really need to see these. And with all due respect, the prosecutors claim that, this shows it all. Well, it does, but it doesn't show the battery that you're saying. That isn't what we're going to see. You can pretend you're seeing it, but you're not. So let's just take a look at it, if I may, okay? And I apologize, you're probably sick of seeing these, but they are important, okay? And without seeing them, it's hard to judge this. All right. Now this is the enhanced, okay? They made it better, so make it easier for us to see. And then we're going to play that. And then I'm going to play it where it's slowed, okay? So you get to see the same thing, but you're going to see it first fast, real time, and then halftime, okay? So if you could play
Judge,
that.
I'm sorry to interrupt, but can you please tell us what exhibit numbers you're displaying?
What number?
This is Exhibit 12.
Exhibit 12.
Thank you.
Thank you. Now, what we just saw was a couple of things. And I don't expect you to see everything you've seen, but we've seen a couple things. We clearly see Josh moving backwards, right? I mean, there's no question about that. And then he does seem to move a little bit to his right. And then we see him kind of launch himself. Can you back this, tap this backwards? See how it looks like he's going up, and it does appear, and I can't tell you I'm sure, okay, I'm not. It does appear that both his legs seem to leave the ground. And then the next thing is, shortly after that, he is falling kind of to his right and down. Now, I'm gonna have her play this, the next one, which is what number?
Exhibit 13.
Number 13. This is the half speed. Thank you. Okay, so again, it's hard because even slowed, it's still a little complicated, and obviously looking through these windows we know isn't perfect. I mean, it's just not perfect. So, but again, it does appear that, well, one thing that's utterly clear is that this isn't Josh standing there and getting punched. This is Josh moving. I'm using the word launching because his legs seem to get off the ground. Now, I'm going to tell you why I think he did that in a moment, but that's what the videos show, okay? Now, of all the witnesses that had some information, all but Mr. Richardson says that Josh had a stool at some point. Obviously, both Mrs. Davies and Ms. Burke are very clear that, yeah, he had it. They hear people yelling that he's got a chair. Mr. Richardson, no, he never had a chair. Now, he has had some issues in the past, and you are able and can consider that incredibility. But it doesn't, you don't get to say, well, you know, I still want you to consider his testimony. You believe him even though what he's saying is different than everybody else. We can't do that. We can't ask you to plug this into make you computers and say, all right, what does all this mean? Well, the state has to prove this case. It's not just like, oh, just figure it out, but it's all okay. Well, it's not okay if you're trying to prove that my client committed this crime, because it's not what they're saying he did. Now, Mr. Laporte originally said that possibly Joshua had a stool or a chair, I think a stool, but later he said, no, that didn't happen. It's a little odd because you would expect him even to say, well, I wasn't sure, but now I'm sure he didn't have it. But in any event, his testimony is kind of not helpful to anybody, quite frankly, because he puts this whole event a half a block away. And if that were true, there wouldn't be any activity over here. It'd be way to the left of this. I mean, it just didn't happen. I don't know why he recalls things the way he does and why he claims he saw what he saw. But it's so out of the range of anybody else's version of what happened. And it is utterly refuted by this video. Whatever Josh and Mr. Sehmer are doing, it's not a half a block the other way. I mean, it's right there. So I don't know what we can say about his testimony other than it doesn't support the state's burden of proof in establishing guilt. Now, do you remember when Mr. Armstrong talked about absolute difference? It's a little... Let's look at absolute difference. What he said, and this is the dark one, the two dark videos, okay? What he says that objects that are darker, that are stationary, and they get lighter if they're in motion, okay? It's weird. I don't completely understand it, but that's what he said it does. So I want to show you these for a minute. There's two, okay? And I'm going to show them to you. They're in different speeds. There's a regular speed and the partial speed, okay?
This is Exhibit 14.
Thank you.
Go ahead, keep playing. Okay, now, one thing that is pretty clear already, just even in full speed, is that this is where Mrs. Sehmer said she was, and there's nobody there. And if she had been there, she would have had to have been moving around here. She would have been very clearly a moving, sounds rude, a moving object, a moving person, okay? She's not there. That's relevant because it's kind of an odd thing to be so wrong about when she was there. She just wasn't there. Right, now I gotta clear this. All right. Now we're gonna play it slower. And what number is this, please?
This is Exhibit 15.
All right, I want you to tap. No, go back. All right, there.
Starting from 4 seconds.
4 seconds. Stop. Back it up just a bit. I know.
I'll do it.
Back it up. Tap, tap, tap. Stop.
Mhm.
This taps, please. Stop. I need you to tap this and it stops there, please. Okay? Don't run it at their speed.
Mhm.
Okay?
Okay. Would you like me to slow it down?
Yes,
Even more for-
but you gotta back it up now. Stop. This. See that? That's it's now lighter because it's moving. Something has just moved, quite frankly, right at his feet. And there's something else that we see, which is this. Okay? You see how there's light there? We went from it being kind of dark. I mean, and it's all moving, but that is a moving object. That's why it looks lighter. That is the stool. Can I be 100% certain? I'm not going to tell you that. All I know is that Mr. Armstrong told us that's how this works. That if something is moving, it is lighter than something that is just stationary. And we've now seen two things. We saw this thing. We've seen that thing kind of come down. It looks kind of towards Josh's feet. And up here is something, now this lighter thing is here. Now, go ahead and let's play it at this point then. I think I have to clear this. I'll go slow. Thank you. We have now seen two things from absolute difference. That's what they call it, so that's what it is. And what it is showing us, two very significant facts. This is the government's evidence. This is the government's expert brought this in. And what we've now seen are two really important facts that I think are somewhat irrefutable. One, something has come at his feet, and two, as he's lunging, as I've called it, we see movement. We see this lighter, whatever they call it, which is something that happens when something's in motion. And what's in motion here is not, as counsel says, him raising his hand. No, it's him with the stool in the position, quite frankly, that his wife had put in his hands earlier. Remember when he said he was like this? And what Ms. Burke says, he had it over his head. Now, of course, he can move, but the notion when she said it was like at this is exactly what we just saw. That's what we saw. Thank you. So, the videos do show that, one, Mr. Davies lunged at him. Two, that Mr. Davies had something in his hand, and it's the stool. Now, I'm not going to claim that I know everything about this absolute difference, but I know what he told me. And what he told me makes it clear that what my client said is accurate. Now, I understand that the state claims, well, this is all Mr. Sehmer's fault. Well, he did get in an argument with him. He did act like kind of a jerk. I get that. And then Mr. Davies comes back in and starts, yells at him and reignites this thing, I wish my client hadn't left, but it's not a crime to leave the bar and yell at somebody who just called you a name. But it's not a crime to do that either, okay? Now, I have to differ with the prosecutor's belief that the medical examiner and Dr. Henson both essentially say, well, it doesn't matter, he was, you know, he really wasn't drunk. I can tell you, I think without fear of contradiction, that no prosecutor in the state of Wisconsin has ever told a jury that a person with a .24 blood alcohol level was not impaired. That has never happened, probably in the history of Wisconsin jurisprudence. Nobody would say such a thing. It's laughable. It's, quite frankly, ridiculous, and it's just a bit offensive, considering my client's on trial. That, oh, 2-4. Come on. I mean, you know, he's got a tolerance. We saw him. Well, yeah, we did see him, but it's a video, and two, we don't really hear him say anything other than yelling some profanity. I don't know. I can't say exactly what how it affects him, but I know nobody in law enforcement in this state or this country thinks that somebody with that much alcohol is not impaired and is not with less faculties. Now, why does this matter? It's not to make him seem like a bad guy. I don't care if anybody gets drunk and not driving. What difference does it make? But in this case, his effort to try to hit my client with the stool is made more complicated because when Mr. Sehmer blocks it forcefully, he doesn't have the ability to right the ship that he's just started down the path. He's up, his feet are kind of off the ground, he's trying to hit somebody, and that person forcefully resists that. Now, we did talk a little bit about the fact that everybody tolerates things differently. Okay, and that's true. But there's a certain level of which, and I think Dr. Henson made it pretty clear that, well, at some point, everybody's impaired. Now, the other thing that's interesting is the medical examiner, she had an opportunity to see all the records, had the opportunity to do the autopsy. What she never said, never provided any testimony about, was that there was any injury to the side of Josh's face. Now, the state is arguing that there was this unbelievably hard smash to his face. But not one bit of medical testimony or evidence suggested that Josh had any injuries, not any bruising, nothing regarding this. Not a bit. So you can say, well, it was really it must have been a hard punch because he hit his head so hard. Well, she then suggested and agreed that, well, of course, if somebody is, pushing and somebody pushes back hard, the law of momentum, the law of motion, okay? You can throw yourself down if you're doing this and somebody's going this backwards, and it appears, Mr. Sehmer being quite a bit heavier, would be in a position to exert far more force than the lighter Joshua. Now, it is pretty hard to argue that my client hit Mr. Davies so hard that he did all this damage, and despite a plethora of medical people, medical personnel, nurses, doctors, and the medical examiner had all these records, and nowhere in there does she say, or did she find, that there was some evidence of any injury to his face. Now, given the degree of force that they're claiming my client exerted on his face, not on a stool that he was holding, that's hard to understand. Now, in Mr. Sehmer's interview, he wasn't utterly candid about everything. I mean, I think, but what the state didn't remind you of is that when he initially said there were two people with the stool, that later in that line, that in the interview, he said, yeah, you're right. I acknowledge it. It was just Josh. It wasn't two people. So when he first said it, all right, he said it. I don't know why he said it. It may have been he was trying to protect himself. It may have been that given the circumstance of these two people, I don't know, I can't speculate. But you can't act as if he didn't say that, correct it. I mean, he did. He said, no, I agree. It was just Josh. It wasn't both of them with the stool or with chairs. So I don't know, other than the fact that what he said is utterly consistent with absolute difference, I don't know what else he could say. Now, as I indicated earlier, there's really two issues. One, did he commit a battery? Nobody, I don't think, is arguing that a person, whether they claim you provoked it or not, that you're allowed, once you provoke something, you're allowed to get hit in the face with a stool and you're supposed to just take it. You can't put your hand up. You provoked this, so you're going to get what's coming to you. That's not the law, okay? Now, the issue of provocation is interesting. You know, it's a judgment you'll have to make, okay? I mean, whether the initial argument where my client wasn't behaving badly, I think is enough to say, well, that's provocation, he doesn't get self-defense. I think most people would hate to think that if I misbehave, 10 minutes later, if somebody, calls me a name and I go want to talk to them about it, even if I am moving fast, that, well, too bad, you're going to get anything you have. If they want to, hit you with a baseball bat, too bad. You were a jerk, so you get to hit in the head. I mean, but is it really a battery? I mean, is that reasonable? First of all, is it a battery to block a punch? Is it a battery to stop a stool that's being swung at your head? According to the state, that's not a battery. Or that is a battery, I guess. I don't know. I mean, because they have to prove that he intended to harm him. That's what a battery is. You caused harm and you intended to. Is it intending to cause harm when somebody tries to hit you with a stool and you block it? That's not intending to harm. That's just stopping something. Even if you go like this. Now, the second issue is, again, so if you say, well, that's not a battery, then the case is over. And did they prove that it was a battery? And remember, as the state acknowledged, they have to disprove self-defense. It's not like I have to prove self-defense. Once this has become an issue, which it clearly is in this case, okay, the state has to prove beyond a reasonable doubt that he wasn't acting in self-defense. And I think it's hard to say if somebody hits you with a stool, you can't block it. So, but it's their burden of proof. But I'd like to talk to you about the burden of proof for a minute. The judge is going to give you the instruction, okay? There's a couple important facts. One, the defendant is entitled to every reasonable doubt, if there's one, okay? That is there a reasonable doubt as to what happened? Now, I alluded to this earlier. If the state's witnesses cannot tell the same story, it doesn't mean you can't convict somebody, but it's hard to say, well, I don't have a reasonable doubt about what happened here when I don't get same stories, or where stories change, where locations change. He starts with the presumption of innocence, and it remains. And it only stops if after you reviewed everything, you conclude that, well, no, he did this, beyond a reasonable doubt. Now, one of the parts of the jury instructions says that if you can reconcile the evidence on any reasonable hypothesis consistent with his innocence, you must find him not guilty. You're not given a choice. If if you say, well, we've considered this evidence, and yeah, there is evidence here that seems to suggest, and it's reasonable, that he didn't punch him, that all he did was block this, that's a reasonable hypothesis. Now, is it the only hypothesis? No, but if it's a reasonable hypothesis, and we know that absolute difference makes it a reasonable hypothesis, it's the actual truth, that Josh was swinging something. Now, the issue of this tripping, I have indicated, and I believe, that there are really three principal things that cause this. One is that he had left his feet and he was swinging a stool, which was blocked. Smaller force met larger force pushed it away, and he fell. The second is that he was intoxicated, grossly so. Now, again, it's not a judgment on him, but it does make it harder for him to do what he's trying to do physically, and it caused him to go down. And lastly, that there does appear, I don't know if you want to call it a trip or what you want to call it, but absolute zero showed that something came right at his feet, just as about the time he's about to, launch. I don't know if that's a trip or if that's just another factor, but those are factors that caused him, I think, in part to go down. But the principle is he's trying to swing a stool, and my client blocks it, and in his intoxicated state, he fell. One of the things that the jury instruction says is that we should consider these things, like what is a reasonable doubt, okay? And it's complicated, but I think they do a pretty good job of explaining it. One of the ways they explain it, because they try to do it in a number of ways, one of the ways is this a kind of doubt that would give you pause or hesitation in acting in the affairs of life, okay? And, lawyers both on the state or on the defense or civil litigation, they all kind of can talk about this a bit, not in civil litigation, but, and they say, what are the kinds of things that we consider that are important in life? And would you not pause before you made such a decision? I've heard examples of if your child needed surgery and the doctors are saying, well, there's this and there's that, you could do this process, you could do this, or maybe you don't do that. And some people say, well, that's something that's an important affair of life. And would this cause you to say, well, I'm going to pause and hesitate before I make that decision? I don't know if that's completely fair, but it does kind of illustrate how important this is. I mean, it really is important. And that is, before I say guilty, before we say guilty, I need not to have those doubts. I can look, I will examine it all critically, but at the end of the day, you can't say that I'm not in a position where I'm like, whoa, I'm really pausing on this. I don't know how you get there. How do we get to, he did this? And I don't think the state did that. I don't think the state can do that. And when you hear the state keep saying, well, there's this problem, that problem, and it's, it's a long time ago, and, I'm sorry, my client's trial is today. And I understand it happened a year ago. But they have to prove beyond a reasonable doubt that he did this. And we don't get to just say he was a jerking tabbies, and don't worry that they can't, keep their stories consistent with the state's theory. You have to say no. There's both a reasonable hypothesis consistent with his innocence, and there are many, many reasons to doubt. And I think there are many reasons to doubt, and I'd ask that you find him not guilty. Thank you.